Okay, I think we're going to go ahead and get started. Welcome, everyone. This is Pete Swisher. I am the National Practice Leader for PENTalk Retirement Services, and we're going to talk today about something incredibly entertaining, 401k plan administration. And we're going to talk about stuff that can go wrong, and I have some folks joining me from PENTalk who all have direct experience with some of the fun things that can happen. And let me start by just giving you a little bit of background about where these stories come from. For those of you who do not know PENTalk, we are an independent fiduciary, a professional administrator, and we have been doing plan administration for 75 years, for longer, in fact, than most retirement plan laws have been around. So we've seen a lot of things happen over the years, and we're one of the largest, most experienced fiduciary administrators in the U.S. And I use the term fiduciary because the definition of the plan administrator in retirement plan law under ERISA is ERISA Section 316. So we use that term to distinguish someone who's the fiduciary responsible for operating the plan, the person responsible by law for that. We distinguish that from a third-party administrator. So we're actually the one responsible for things going right. And we need help from our clients, and it's a team effort, but we are the fiduciary responsible. And so these stories come out of that experience. So joining me today, I have some folks who have firsthand experience with plan administration. So Joe Reese is a regional director with PENTalk, has over 20 years experience in the industry and is in the field, and therefore gets to see things happening, plan administration, from the client side of the table, from actually at the client's premises and how things are going in the field. Mike Sorosky is a 316 administration manager and relationship manager, which means he personally interacts with a lot of our administration clients, and specifically our clients where we serve as a plan administrator. Mike has 10 years of experience in the industry, and so does Nick Rice. Nick Rice is also a 316 administration manager with us, has 10 years of experience in the industry, and all of these gentlemen have direct experience of things that can go wrong. So I'm going to give a couple of basic concepts, and then we're going to go into just some examples of what can go wrong, and hopefully we're going to leave you with a sense for what you can do about it and how you can keep things simple and heading in the right direction. So let's start with, why do things go wrong? And what I've seen over the years is that the industry, the retirement plan industry, tends to respond to things going wrong by saying it's the client's fault. So something went wrong. The 5500 didn't get filed. Why didn't it get filed? Well, the client didn't sign it and send it in. Why didn't the ADP testing get done on time? Well, it's because the client gave us incorrect data on the census. So this is a fairly common set of circumstances. Something goes wrong, and the folks doing the administration, third-party administrator, record keeper, tend to look at that and go, well, what's going on here? And the answer is the plan administrator didn't do something. And if the plan administrator is the client, then it's the client. And so in essence, the industry is saying it's your fault. And my experience is nobody likes that. So clients do not find it helpful when we tell them, oh yeah, that's your fault. So hopefully we can be a little more useful than that. So yeah, it is in fact actually a lot of the things that go wrong. It's true that some of those originate with the client, but there is much more to it than that. So let me give you a sense for what the work is. We use this document, the 50 Chores of the Plan Administrator, to help convey a concept, and that is that there are literally hundreds of separately identifiable legal responsibilities that the 316 plan administrator, in other words, the fiduciary named in the document, the plan administrator, that person has a long list of responsibilities. And it's nitpicky stuff. It's things like what you see on the screen. And in a typical retirement plan, the employer is named as the plan administrator, but one or more individuals are appointed to do the work of the plan administrator. And the way retirement plan law works, those individuals are fiduciaries under ERISA, the Employee Retirement Income Security Act of 1974. ERISA is our basic retirement plan law. And so that plan administrator is technically responsible for all this stuff, but gets help from a third-party administrator or record keeper. That is a normal arrangement. A customer who is one of our 316 clients has us as the plan administrator. So the client still has responsibilities, but not this stuff for the most part. They have responsibilities related to this, but not this stuff. So that's the distinction I want to draw. So as an example, I mentioned the Form 5500 earlier. That has to get filed. Well, somebody has to prepare it, but then the plan administrator has to sign it. And if you don't sign it and send it in, you have a late 5500, you have to do a filing. It's that sort of problem that we're looking to figure out how to solve. Stuff does go wrong, so I'm not going to go through this stuff. The point of this slide and the following slide is that things do go wrong all the time. As an attorney friend of mine says, there's a lot of breakage in plan administration. There's something called a voluntary fiduciary correction program with the DOL. There's a voluntary correction program with the IRS, and there are tens of thousands of these things that happen. It is real. It's normally not catastrophic. It's mainly annoying and time-consuming and a little bit expensive, and typically stuff that clients would rather that they not have to deal with. But it does absolutely happen. And the IRS publishes this list of their most common filings for people making corrections. And I think we'll hit on a couple of these when we talk about the things that we've seen. So let's go on and tell a couple stories. So Joe Reese, let me start with you. Tell us a story about 401k plan administration.
Sure. How's it going, Pete?
Going great.
Good. So, when you started, you talked about being in the field, and it's true. When you're in the field, you get to see some interesting things, some unblemished truths come to light. So, a while back, I had an interesting meeting with a CFO of a pretty large physician practice. It had between 15 and 20 million. I don't think they were quite an audit-sized plan, but they were bumping up against that. And the CFO, he had a lot of experience. He came from an accounting firm. He did most of the HR functions. He did have some payroll, support staff, but he was the primary person handling it. So I was just asking some open-ended questions about the plan operation, just trying to see kind of what they were doing and how they were doing it, and it's bouncing around. But eventually we got to talking about delivery of required notices. So I'd ask him just generally, are they using electronic delivery, or are they mailing out the notices? And he said he didn't have to, because his notices were being sent by the service provider, that his service provider did that for him. So, I believed him, but I wanted to verify it a little bit more. So I dug around just to see if I could get some clarification and, determine exactly what that service provider was doing for him. So I asked him, kind of what happens. And he said, well, they email me, the notices and for me to review, and then I just delete them. So that sounded kind of suspicious. So I just said, so you're a participant in the plan, correct? He said, yeah. I said, so are you getting these notices then as a participant? And if there had been the proverbial light bulb going above the head, he kind of looked at me, and it dawned on him that, maybe he shouldn't have been deleting those, because they were actually sent to him for delivery, not to be deleted. So I think that kind of gives an example that oftentimes there's miscommunication between service providers and the plan sponsor, the employer, or maybe an expectation gap as to who's really doing what and who's responsible for certain things. And for this guy, even though he'd been a very experienced person, he just saw it, said, well, I guess the service provider just sent it to me as a heads up, and he deleted it, never actually reading through the email to determine that it was his responsibility to be delivering these notices.
Thanks, Joe. We that's funny. This is one that we see a lot. Notices are really annoying in a couple ways to our clients. But one of the things that I hear is, yeah, but realistically, how big a deal is that? Well, we had an example a couple years ago of maybe an extreme variant of what can happen, but actually not an uncommon thing. That if the notices are not being sent, and that means not just are they being sent, but are they being sent correctly? And correctly means you might have to deliver paper to people you'd rather email, but you have to deliver some paper, and then somebody has to manage which stuff are we allowed to send electronically or post onto some kind of website versus what do we have to mail. In the situation we had a couple of years ago, there was a client who did not send out the safe harbor notices. And so when we picked up this client, we realized what was going on. So if the safe harbor notice, if you're a safe harbor plan, you don't send that by the end of the year, you're not eligible for the safe harbor, and that means special testing has to be done. And if you don't pass the testing, there are contributions required and maybe refunds to highly compensated employees. So it turned out that because this hadn't been done, they didn't qualify for the safe harbor. They would have failed the testing. This wasn't caught for a couple of years. So it turned into a fairly expensive correction for that client, and it was caught on audit. So this was one the IRS actually picked up on, and once they catch you in an audit, it's much harder to get an affordable correction. So they needed an attorney. So that's a fairly extreme example of what can happen if you don't send the notices or send them correctly. So thank you, Joe. And let me move. Let's do another one. Mike Sorosky. Mike, you and I have had interactions on a couple different cases over the years that have been entertaining and tough stuff that is tough to wade through. But give us an example of a situation you've had with a client.
Absolutely. Thanks, Pete. So in this case, one of our 316 clients, they're a supermarket chain, audited plan with several thousand participants, high turnover and heavy Spanish-speaking population. The client reached out to me to ask how to handle a situation where a participant had contacted them inquiring about his account, but the only thing that they had to go on at the time was the first page of an old statement from their previous record keeper. So the statement showed that 100% of the participant's account had been forfeited back in 2015. Now, that was before Pentegra was the TPA or the 316 plan administrator on the plan. So at the time, I provided the client with instructions to reach out to their prior record keeper to research the issue and to have the participant reach out to the prior record keeper as well. Because we weren't affiliated with the plan at the time, the prior record keeper was not going to give me any information, and ultimately it would be the client's responsibility to resolve in that case. So I provided the contact information that I had available to me, and I even tried to reach out just to see if I could get anything from the prior record keeper a handful of times. That didn't go anywhere, but the client, assured me that they would resolve it, and then we moved on with the regular administration on the plan. Well, a few months later, the head of our TPA gets a call from the Department of Labor, the head of our TPA operations, I should say. And typically when your caller ID pops up and it says Department of Labor on it, you let that one go to voicemail just so you can kind of see what you're dealing with there. It turns out the participant had written a letter to his local district attorney's office, who then forwarded that letter to the Department of Labor, Now, I wasn't able to obtain a copy of that letter, but from what I gather, I sincerely doubt that the client or the participant themselves ever tried to pursue the issue with the prior record keeper. Now, the Department of Labor called the head of our TPA operations because the head of our TPA operations is the one that signs the 5500. So his name is on the 5500. He passed the issue to me because of the plan that I was the relationship manager on. And as soon as he walked in my door and said, hey, the Department of Labor gave me a call on X plan, I said, it's for X participant immediately. I knew what it was. So at that point, I jumped in to resolve the issue and prevent a full-scale audit of the plan. The Department of Labor was able to get me in contact with the right people at the prior record keeper. I was able to get further authorization from the client to speak on their behalf and get any of the information that I need. It did turn out the participant was, in fact, forfeited in error due to an issue with the way that his account was initially set up by the client. So it took a lot of back and forth with the client and the prior record keeper to resolve. But in the end, Pentegra was able to resolve the issue. We calculated the rate of return the participant would have received had he not been forfeited in error and pulled that total amount due to the participant from the plan's forfeiture account to make him whole. So really the moral story is here is when the Department of Labor has an issue and they pick up the phone to call someone, they're typically going to call the person that is signing the 5500. And in this case, because we act as 316 plan administrator, that was Pentegra.
So Mike, help me out with this. I'm pretty sure that you just said on a recorded line that when the Department of Labor calls, you blow them off and let them go to voicemail.
I didn't say blow them off. I just said prepare for the conversation.
Yeah. That's, so there are a couple things here. the Department of Labor has customer service reps, and actually, I don't think that's their title, but they have a hotline. So if you are a participant in an employee benefit plan and you're having trouble, or you think there's something going on that's not right, you can call the Department of Labor and say, I need help with my account. And then they're usually really good. They will call the plan administrator and they will try to resolve things. And they're certainly insistent about getting it right. So they're not going to let you do anything other than what the law requires. But they're calling not to get you in trouble. They're calling to take care of the participant. And it will only be trouble for you if you don't do the things that you need to do. So like in this example, let's say there was no money in the forfeiture account and the employer didn't want to have to write a check. Well, the employer's going to have to write a check, and there's not going to be any two ways about it. And it's the plan administrator's job by law to look out for the participant. A fiduciary's duty is to the participant, and the Department of Labor works for the participant. So, but it's actually a good system. It does, the other point I would make here, it does also sometimes lead to investigations. So if the Department of Labor gets a complaint and then maybe another complaint about a particular plan, depending on the nature of the complaint or the number of them, they may launch an investigation. So they are watching. They don't audit even 1% of plans per year. But you can see if you check out our statistics and surprises slide that I had up earlier, you can see they actually pursue quite a few cases, and they file some criminal indictments, and they recover $1 or $2 billion every year on behalf of participants. So it is a big deal. So thank you, Mike. Nick Rice, tell us a story about plan administration.
Yeah, so we have a client, significant size 401k client, where we uncovered during the annual valuation we were conducting that this client was excluding bonus compensation from the employer contribution. So they were using the wrong definition of compensation, which is actually a common mistake made by plan sponsors. So they're excluding bonus compensation, but this is not how the plan document was written. They should have been using bonus compensation in the calculation to determine what the employer contribution would be. So at that time, we knew we had a problem. It was a new client of ours, so the first time that we had our hands in the weeds and conducting this valuation. And the first thing we did, we needed to have a conversation with the client. And what we did, we asked what their intent was. Was the intent truly to exclude bonus compensation, or was the intent to include bonus and the employer contribution? And we learned that their intent was to exclude bonuses. So they were operating how their intent was, but not how the document was written. And this client, they even found handwritten notes, meeting minutes from going back over 15 years, where it was clear that they had discussed this exact item, and it's clear that their intent was to exclude it. So our first order of business then, one, we educated them and let them know, look, the plan document is what we must follow. So we amended the plan to make sure that it matched how they were operating. And then the next order of business was to identify how to correct the problem. And this is where we are today. So I wish I had a big aha moment saying we filed a VCP, came back, all good news, no, they took the story, no penalty. That's what we're hopeful of. We filed a VCP anonymously, so the client's name isn't on it. So anonymously provide a clear, concise summary with all the details, including the meeting minutes, laid everything out there as detailed, as thoroughly as we could to explain to the DOL that, look, this is how the plan has been operating, this is the intent, this is what we would like to see happen. So we're waiting to hear back, and we're hoping for good news. But my point in bringing this up is that using the wrong definition of compensation is a common issue that plan sponsors get wrong, and one that they just don't know what they don't know, and a lot of the time it doesn't catch up to them until it's too late when the IRS or a DOL auditor is in there. In this case, we caught the error during our annual valuation. Now we're able to get out in front of it.
So Nick, VCP, Voluntary Correction Program, it's an IRS program, and you mentioned there's an ability to do that anonymously. So, in other words, this client is trying to get their correction done in a way that is acceptable to them, and they're hoping the IRS will accept it. They may or may not. Because it's anonymous, if the IRS doesn't accept it, they can still correct formally some other way. We can explore other options. But let me ask you a question. I think in these situations, it's normal for the client's first reaction to be compensation, definition of compensation. I don't know what you're talking about. Isn't this what I hired you for? So we caught it at the end of the year, but somebody else should have caught it earlier, maybe, prior service provider. But can we catch this? Is this something we should be able to catch, and how would we catch it?
Yeah, they made a comment, add it to the list with the prior administrator they had worked with at the time. But the way we're able to catch it is at the end of the plan year, we obtain all census information, and we break down compensation into different fields. So we know all the different levels of compensation that their employees are receiving. Then we compare that to the plan document with how the plan should be operating.
So, and I've seen this happen a couple different ways, and the point that I'm drawing out for everybody is that it's very often the case that we have no way of catching this. So there's those 50 chores that I showed you earlier. That's a lot of stuff that we're responsible for when we're the plan administrator, but we still have to get good data. So the two primary responsibilities that any client has, even if they've outsourced administration, they got to give money when it's owed. So when the participant deferral contributions have to be sent in, they need to be sent in right away. Any other fees, expenses, contributions, it all has to be sent on time and correctly. And then data, information about the company, about the employees, and the biggest part of that is payroll. And along with that, the end of year census. So let me give you an example. Let's say that an employee made $35,000 in 2017. We get a report from the client that says that their compensation was $33,000. So that the employee's real compensation was different from what was reported to us. And we have no way to catch that. Now, maybe we'd be able to catch it because of what Nick mentioned, that because the census is broken down into components of compensation, we can notice, hey, wait a minute, there's supposed to be bonus compensation there. But even then, we don't necessarily know if somebody is owed a bonus or not. So only you know about your employees, only you can verify that that information is correct, and we do not necessarily have any way of knowing that data is right or wrong. So this is one of those areas where you can make a huge difference. If you're an employer, you make a huge difference with the payroll process and with the end of year census validation. All right, so I think what I'm going to do is I want to highlight just a couple of key points, and we will wrap up and maybe have time for a few questions. So I think probably the most important point that I could make is that good administration comes from good data. And if the employer sends us good data, it's our job to do the right things with that data. But of course, it's garbage in, garbage out. And as Nick mentioned, compensation is a big one. That's a big area where things go wrong. It is the number 2 most common voluntary correction program filing with the IRS, VCP filing. Number 2 most common is a failure to report the correct or to use the correct definition of compensation or report the correct compensation. And it leads to just all kinds of different problems. But usually it leads to an incorrect amount of money going to somebody. And that can be a painful thing for the employer. So even though maybe they would have had to pay the money if they had gotten it right, it's not good news when you hear after the fact that you owe X amount of dollars for this stuff. So the payroll contribution, we insist when we have a rule at Pentegra, no data, no dice, that if we're going to be the fiduciary of the plan, we're going to take on a whole bunch of stuff. That's all going to come off of your plate. But we need the data. and that means full data every payroll period. One of the things that happens with that is that at the end of the year, the client thinks, oh, great, I've been giving Pentegra this information every payroll period, so they have a full census, and therefore at the end of the year, I don't have to go through that awful, painful census process where I generate data and validate that data. And unfortunately, I wish that were true, but it doesn't work. So we really need you to validate the census information at the end of the year. And I'll give you an example. And I gave the example earlier of an employee whose compensation was supposed to be, I forget what number I used, 35,000, but the client reported 33,000. How could that be? One example would be if the reporting during the year that we're getting is cash compensation. Well, what if they got a moving allowance? What if they got a bonus of some sort, or some non-cash compensation, or just one of these other items of compensation that gets added at the end of the year to the W-2? What if there's a bonus payroll where there are no deferrals? Well, clients don't typically send us a payroll file for a bonus payroll unless there are deferral contributions to the 401k. So there are all kinds of reasons why the census, the end of year correct information will not match up legitimately with the week by week or month by month payroll submissions. So there's that end of that data validation. So if you get the data right, a couple things happen. Number one, the number of problems goes down dramatically. And number two, pretty much every problem that can happen is now our problem and not your problem. So final thing I'll say is, how do you set yourself up to win? If you're an employer, how do you set yourself up to win with good administration? So a couple things about that. One, most clients don't want to do any administration. So if you don't want to do administration, you want to do as little as possible. Having a professional administrator helps. So a lot of you on the call are our clients. Thank you. That's what it means for us to be 316 administrators. We take off a lot of that stuff, but we can't do it without payroll, without information about the company, without somebody to interact with to make sure we're getting it right. So being willing to do the parts that are left. We can't take all of it. We can take most of it. There's a little bit left, working with us on that. And finally, smart design. So an example of smart design would be, one of the things I like about Nick's example of that definition of compensation. We understand why that client wants to exclude bonuses, but excluding bonuses is dangerous. It's a dangerous, semi-dangerous administrative method. So one of the things you can do is you can limit your chances of things going wrong with a plan design that sticks to easily administered, non-error prone, tried and true methods, and we can help with that. So a smart design, a professional administrator, and a client who is comfortable doing the few things that remain to them, that's a formula for success. So I thank you all for joining. I hope you found this useful, if not entertaining. And at this point, there are a couple ways that we can take questions, but I think that we will, the best way for us to do this is with the chat function. So if you look, the questions, there is a place for you to enter a question. So if you do have a question, then feel free to enter that in. And while we're waiting for that, Joe and Mike and Nick, thank you all for your stories. Any other comments that you would like to offer about the things we've been talking about?
No, I'd say, just continuing, if you're in the advisor position and being proactive with your clients and helping us stress the importance of the data we receive, being able to help us effectively administer the plan, that's a key for us to have a partnership with the advisor to be able to help us get the data we need. It's invaluable.
I would just add that from an advisor's perspective, never assume. Just ask, have a lot of open-ended questions that you can ask. Talk about, ask if there's if they can provide you with a copy of the document, signed document. I mean, it's really, oftentimes it's these little things that trip people up, they get lost. So I would just say, just ask a lot of questions and really try to help them understand the plan sponsor, what's involved and what they might be missing.
All right. Well, we do not have any questions at this point, and we want to keep this short and to the point. So I'm going to say thank you to everybody for joining us today, and thank you to the panelists for joining us. Thanks, everybody, and have a great rest of your week.